David Garofalo. I'm the Director of Marketing and Communications here at IANA. I'd like to start by welcoming you all to today's webinar, California AB5 and the Future of the Independent Contractor Model. We're very happy you could join us on short notice for such an important discussion. I'd like to turn things over to Marc Blubaugh, who is the partner and co-chair, Transportation Logistics Group with Benesch, Friedlander, Coplan Aronoff. And he is also IANA's legal counsel, so he is intimately familiar and dealing with AB5, and he's here to share his perspective today with us. So Marc, thank you very much in advance.
Absolutely. I appreciate the invitation. Thanks for the introduction, David, and good to have all of you here with us today. And thank you to IANA for supporting the webinar. So what I'm hoping to do in my allotted time is really threefold. One, I want to talk a little bit about how did we end up here? A little refresher on what AB5 is, the litigation background, and the current state of AB5 and enforcement in California. Second, talk a little bit about some of the possible solutions that might exist to help the transportation industry adapt to this new environment. And then finally, we'll take some questions that IANA has been receiving relative to AB5, and I'll do my level best to answer those as well. So let me kick it off, just a real brief refresher on what AB5 is. I presume everybody who's logged in is familiar, but I'm still surprised on occasion that folks may not fully appreciate what the law is. So just stepping back in time briefly, 2019, California passes AB5 governing worker classification, and the statute is supposed to be effective January 1st of 2020. And what the statute does is impose what's called an ABC test to determine whether a worker is an independent contractor or an employee. And there are different kinds of ABC tests in various contexts in other states, but California's ABC test is among the most restrictive that exists. And what the test is, it's a three-part test, as the ABC suggests. It essentially says, look, a worker is going to be considered to be an employee rather than an independent contractor unless the hiring entity, that putative employer, can demonstrate that each of three conditions are satisfied, the A, the B, and the C. So the A prong is pretty customary in a lot of classification tests. The worker has to be free from control and direction of the hiring entity. That's something that we're fairly accustomed to. The third prong, the C prong, is also not a very heavy lift. It's usually the person has to be customarily engaged in an independently established trade or business or occupation of the same nature as the work they're performing. There's a little bit of ambiguity about what independently established means, but for the most part, the C prong is not a big problem. It's the B prong in California that creates the real challenge, and that is that the person who is performing work, this worker, has to be performing work that is outside of the usual course of the hiring entity's business. That's the real key element here, because if you think about motor carriage and drivers, the argument from the state's perspective is, well, a motor carrier provides transportation from A to B, and the driver is providing transportation from A to B. They are both providing transportation of goods, and therefore you cannot satisfy that B prong of the ABC test. So what was this litigation? So CTA, the California Trucking Association, already had litigation pending against the state of California in federal court to attack the Supreme Court's, California Supreme Court's decision in Dynamics. So when AB5 was enacted, CTA amended the complaint in that litigation to attack AB5 under a number of theories, including the key theory here that the statute was preempted by a federal law called the F4A, the Federal Aviation Administration Authorization Act, a real mouthful, but we generally refer to it as the F4A. And what that statute essentially says, Congress enacted it in the mid-90s as part of deregulation. And Congress said, look, no state or any political subdivision of a state, a county, a municipality, et cetera, can enact or enforce any kind of a statute, a law, regulation, an ordinance, any provision of law that is related to a price, a route, or a service of a motor carrier. And the purpose of this legislation, again, was deregulation. Congress wanted to create uniformity for the trucking industry, predictability in your operations so that you do not need to worry about complying with 50 states' various laws, let alone the laws of various counties and municipalities or other political subdivisions of a state as you perform your services from one state to the next. And it was, again, part and parcel of various deregulation efforts. In the 70s, Congress deregulated the airline industry, and this statute was based in large part on that deregulation of the airline industry and was part of, in the mid-90s again, terminating and sunsetting the Interstate Commerce Commission. So in the litigation, CTA said, look, this AB5 is effectively mandating that motor carriers treat owner-operators, independent contractors as employees rather than the independent contractors that they really are. And that by enforcing this law, it would create imminent, irreparable harm to the industry because otherwise you all would have to engage in significant and costly compliance measures. So the wonderful news was on New Year's Eve of 2019, we all got news that the federal district court judge did grant that temporary restraining order, preventing the state of California from enforcing AB5 against the trucking industry operating in California. A couple days later, that temporary restraining order was converted into a preliminary injunction. Eventually, there was an appeal. Unfortunately, in 2021, in April of 2021, the Ninth Circuit Court of Appeals reversed that decision and says, we think that the federal district court judge abused his discretion, that the F4A does not preempt this statute. They thought that AB5 was a law of general application in general is what they said. But the Ninth Circuit, to its credit at least, did stay its decision and said, we're not going to yet tell the district court judge to reverse the injunction because we know the parties are going to take this up to the U.S. Supreme Court if the court will entertain it, because it's a discretionary decision on the part of the U.S. Supreme Court as to whether or not to hear a given case. And they get thousands, 7,500, 8,000 requests a year to hear certain cases, and they take maybe 100 or 150 of them. But the court said, look, we'll stay our decision. So fast forward to June 30th, last month, a few weeks ago, and unfortunately, the U.S. Supreme Court declined review of the decision, despite many efforts on the part of the industry, compelling arguments made by all, including by IANA, filed an amicus brief before the U.S. Supreme Court on the subject, trying to emphasize that this was an issue of great public importance and an opportunity for the court to provide some clarity with respect to the scope of this federal preemption. So the very next day, July 1st, first day of this month, the Ninth Circuit issued a mandate, it's called, essentially telling the trial court, hey, our decision stands, it's time to implement. And there's nothing on the trial court's docket yet, other than an interesting notation that a hearing has been set for August 22nd of this year. And it's a kind of unusual phraseology that's used in that notice that says there's going to be hearing on the notice of what is called spreading the mandate. Essentially saying, look, there's a hearing 10:30 a.m. that Monday morning on the 22nd in a specific courtroom before Judge Benitez, and the parties need to be there. Now, I don't think that anybody, including the parties probably to the underlying case, yet know exactly what the agenda is for that August hearing, but I'm quite confident it is not going to be entry of another injunction. I've heard some people suggest that that's the case. Oh, don't worry, the injunction is going to remain in place, or it'll be revived at that point. The district court judge has zero authority to vary or examine the appellate court's mandate and decision, other than for the purpose of executing that decision, for implementing it. In other words, the lower court can only consider and decide issues that remain open in that litigation. So in all likelihood, the purpose of this hearing is to discuss with the parties what the next step will be in that underlying litigation, because keep in mind, that case involves a lot more than just whether AB5 was preempted by the F4A. I'm sure and know that CTA is considering various strategies as to what it will be doing in that litigation going forward. But I don't want anyone to assume that California can take no action now simply because the district court judge hasn't technically entered an order dissolving the injunction. The lower court has notice of the Ninth Circuit's mandate that it issued. It has notice of the decision. And I would say that given the circuit's reversal of the injunction and the issuance of its mandate, the injunction for all practical purposes is not in effect. And I don't think that a district court's order formally dissolving the injunction is technically required. The exposure exists right now. Even if a legal argument could be made or advanced to the contrary, it would probably be a fairly fleeting argument that would be made. So what are the consequences now that AB5 is in effect? You know, the statute exposes you to a wide variety of possible consequences. Application of all California labor laws. So think about retaliation claims, discrimination claims, and the like. Misclassification exposure for unemployment insurance or for workers' compensation purposes. Civil penalties that may be imposed for willful misclassification between $5,000 and $25,000 per violation, or in fact possible. Now, some of that exposure is mitigated on other grounds. There might be other arguments that can be advanced. For instance, keep in mind FMCSA has preempted meal and rest break rules in California for drivers who are subject to the hours of service regulations. So that might be one issue that can help mitigate some of the risk. There's federal overtime exemptions benefiting motor carriers under certain circumstances under the Fair Labor Standards Act, et cetera. So there are a couple of ways to possibly mitigate that risk. And then unionization, of course, is another risk because independent contractors cannot be unionized, whereas employees, of course, can. And you all understand that labor interests were behind much of what we see in AB5. So what does all of this mean as a practical matter for the market? Certainly to begin with, certain carriers are going to exit the market. You know, some small carriers are going to say, look, it's just too daunting, too expensive to convert to an alternate model. So we are going to see some exits undoubtedly from the motor carrier industry. That may be more pronounced in certain sectors more than others. Intermodal drayage, it's been a longstanding target of the powers that be in California. So sadly, we are all in the crosshairs, squarely in the crosshairs. Even large carriers are going to be challenged and have to consider what they want to do under the circumstances with all of these drivers now in jeopardy. But most, I would say most operators are looking at alternative options and ways to comply, if possible, in California. So I want to review a few of those theoretical options. And let me be clear, I am not providing any participant in the webinar with legal advice as to what you in particular should be doing in your specific business. You each have your own unique issues relative to structure, your history, maybe tax issues, etc. So the options that I'll kind of go through and review each have their own risk-reward analysis. They may have operational or tax implications for each of you beyond what we're touching on here. So among other things, speak to your counsel, your accountants before you pull the trigger on any given option. I don't want somebody to walk away from this and make a snap decision and then find out that you have created more problems for yourself in the future. So let's start with the first one option, and that some are entertaining, although I don't think it's very viable for most drayage operators, is business as usual, but with a kind of jurisdictional geographic analysis as part of it. So this starts really with an operator saying, look, okay, well, California, does California law apply to a given driver or motor carrier in the first place? So if we think about other aspects of employment law, at least with respect to one aspect of employment law in California, it's pretty well settled that California says, look, our law applies to non-resident individuals that are performing work in California for California-based employers. There's some case law to that effect. Now, the case law remains unsettled, I would say, as to whether California law applies to out-of-state drivers providing services to out-of-state companies, particularly where the drivers spend only a portion of their workday in California. Again, this is a very gray area, not much guidance, but what some are considering doing or are in the process of doing is analyzing kind of driver by driver who is performing in California relative to other states or adjacent states in order to kind of advance an argument that the worker in question, or maybe the motor carrier itself, provides only a small percentage of work in California relative to others. Now, this is not as simple as you being a California operator creating an Arizona PO box for yourself or for a driver and claiming, hey, we're not subject to California law. There's not a bright line analysis here, but it can help mitigate the risk. Again, I don't know this is going to be particularly helpful, though, for most drayage companies performing that type of work. You're not necessarily going to be pulling someone in from Nevada to haul at the Port of LA or Long Beach, for instance. So, but it's a theoretical exercise that you could go through and perhaps mitigate risk and give yourself a little peace of mind. So now the second option that obviously is getting discussion is the simple solution, so to speak. Not that it's simple to implement, but it's the obvious one, which is conversion to an employee model. Now, there's a variety of hurdles and challenges there, of course. Most fundamentally, perhaps persuading an independent contractor to become an employee in the first place. There's a reason that they're an independent contractor. They like being an independent contractor, a small business person with some control over their own destiny. If you do go the employee model route, obviously there's going to be new processes you'll be putting in place to implement payroll withholding, to provide employee benefits, to comply with a variety of labor laws and the like in California. You'll have to think about that risk of unionization that I mentioned earlier. And again, I think it comes back to a lot of kind of cultural transition and onboarding challenges that you may have in implementing that model. But it's the obvious one and not very appealing for most of you out there, I'm sure, but there are some who, in fact, are deploying that model. I know it for a fact. So let's think about another one. A third possible option in the market it's a slight variation on employment, but we refer to it as the two-check model generally. So what you have here is a motor carrier paying a driver two things. One, a kind of W-2 wages for services rendered, provided, and second, a self-employment payment for leasing his or her truck to the company. So again, first check is for payment of wages. That would be subject to deduction for Social Security taxes and other withholding. The second check is payment for use of the truck on a Form 1099, and the owner of that truck would report that payment as net earnings from self-employment. Social Security Administration has recognized kind of the divided reporting in certain instances. The upside of doing that is, well, you have a little bit less withholding that you have to worry about, and you don't need to purchase the truck. You're actually paying somebody for the use of the truck. The downside of this approach is, of course, that an actual employment relationship is established, and the corresponding laws, employment laws, labor laws, and the like, applicable to a genuine employment relationship come into play. There are slight variations on all these models, including the two-check model. A slight variation is where the owner of the equipment might create a separate entity that actually holds that equipment. And so you're, again, making one check payable to the individual, another payable to a business entity under a federal employer ID number, rather than directly to the driver as an individual. So that's another option that's been discussed. The fourth option that is worth consideration is what's known as the business to business exemption. This is in the AB5 itself. It's expressly provided for in the statute. The challenge is, to take advantage of this, you have to satisfy all 12 of the specific criteria set forth in the statute. Some of those criteria are fairly easy. The owner-operator has to create a bona fide business entity, for instance. And also one of the criteria, for instance, is that the worker can't be performing work for which a license from what's called the Contractor State License Board is required. Drivers don't need that, so it's an easy check the box, so to speak. Some of the factors are fairly customary. Again, the lack of control element, for instance, that we hear thematically throughout any classification issues. But there are some that are challenging. They present some specific hurdles for those in the trucking industry. For instance, that one is that the entity or the driver's entity must hold itself out as being available to provide similar services to others. That doesn't always fit well with the business model that you are all deploying. So it's theoretically possible, it's achievable, but there are hurdles. And the kicker is, even if you satisfy all 12 of these specific criteria, it's not like you're off the hook entirely. Then you are still subject to the Borello test in California that is rigorously applied by the California Labor Commission in favor of finding employment more often than not. So virtually all the time, it seems. So it's doable, it's achievable. There are some risks, of course. One thing to keep in mind too, and this is don't lose sight of this fact, the Solicitor General, in her briefing before the U.S. Supreme Court on why the court shouldn't take the case, is that, well, preemption isn't available here because the B2B exemption is available. It's an alternative path for motor carriers to comply with AB5. She recognized that. The state appellate court in the Cal Cartage case that didn't find preemption found something similar and said, the B2B exemption is available to motor carriers. So you've got something in your back pocket to at least say, hey, we're not acting willfully. We're trying to comply with the B2B. We shouldn't be subject to any enhanced penalties for sure. And it's a viable path. So that is another one to think about. The fifth option that is worth consideration is what I'll refer to as the broker carrier model. So here we've got a business that is currently operating as a motor carrier, creates an autonomous entity. You may already have one, in fact, that applies for and obtains freight broker operating authority. So then the former independent contractor driver creates a business entity and obtains federal motor carrier operating authority in and of itself, and the requisite public liability insurance, and adopts safety policies and the like. And then the broker entity tenders to the motor carrier entity, and by doing so, satisfies that B prong of the ABC test, in theory. These are different businesses. The motor carrier is providing work outside of that broker's usual course of business. So before we had motor carrier to driver, now we have broker to carrier. And the broker is the source of freight. It's arranging for transportation, but it is the source of freight and cannot and does not provide transportation. The law requires it to have a different license and to hold itself out to the public in a different way. And then you've got the motor carrier that performs the transportation. So arguably, you can satisfy the ABC test in those instances. And maybe your broker entity might also provide some ancillary services to that motor carrier to help it along the way. Maybe there's some back office support, some regulatory compliance services that you can provide to the motor carrier as a result. And that's one of the more attractive options in the market right now, I think. Then finally, there are a variety of other alternative, maybe more innovative models, and I won't get into the weeds on all these, but there's a taxi cab medallion model, for instance, that we refer to, with several moving parts where a motor carrier is essentially granting non-owner use of its operating authority, kind of donating it in a way for others to use. There's a third-party administrator involved who's actually paying the driver. There's a driver making payment to that matchmaking entity for use of the authority. Fairly complex structure, but there might be a good path to compliance. Variations of that involving control towers, where a broker might be serving as a clearinghouse for a variety of affiliated motor carriers. There's newer models we kind of refer to as the owner-operator resource model, where certain core functions are centralized for affiliated motor carriers. In theory, there's this idea of a Prop 22 workaround as well. Remember, when Prop 22 was enacted in California, it's for app-based workers, but the putative employer has to pay certain specific benefits like workers' comp and paid family leave and unemployment insurance and the like. But that Prop 22 was found unconstitutional, and the court decision in California turned on specific language in the California Constitution that expressly granted the California legislature the power to regulate compensation for workers' injuries. So as a result, you'd have to go get a constitutional amendment and the like. So it's not really viable right now, but it's a theory that may play out over time as that case challenging Prop 22 goes up through the courts. So those are some of the basic alternative models and solutions that we're seeing in the market. But I know that, David, you have, the association has been receiving some questions from members and others about AB5. And so if you want to toss some of those out to me, I'm happy to take a stab at each one of them.
Absolutely. And Mark, thank you for covering a lot of ground in the last 20 minutes. That's quite impressive. First set of questions, that's going to have a couple parts to it. When does AB5 take effect and how will it be enforced? Is there any transition period before enforcement? And will it be enforced retroactively? And if so, what can or should companies do to be prepared?
Okay, let me take a stab here. So when does AB5 take effect and how will it be enforced? You should treat AB5 as effective currently due to the appellate court's mandate, as I was suggesting earlier. The way it's going to be enforced, really two primary enforcement mechanisms. One is the Labor Commission and actions that it might commence. The state itself, in other words, acting. The other is private party litigation, a disgruntled driver who decides to take advantage of AB5. It's unknown right now, a lot of speculation about how quickly and how aggressively California will be in taking those steps. I note that last Tuesday, a week ago today, the labor commissioner, and many of you have probably seen this, sent out a tweet saying, hey, the courts have ruled that AB5 applies to the trucking industry. Drivers, submit your complaints, your reports of violations to us and request an investigation from our office, and we're on it. So California is certainly treating it as if it is in effect and that they can act upon it now. Some of you may also know that Lorena Gonzalez, who is the lead author, sponsor of AB5 in the California Assembly, is now California Labor Federation leader and has, in theory now, tens of thousands of new potential California employees that could become potential union members. So I'm sure that labor is going to be capitalizing on what she accomplished in passing AB5 in the first place. So that's something to keep in mind as well. Now, this whole notion of the transition period kind of ties into that before enforcement. Again, to kind of reemphasize this to everybody, there is no technical transition period. As a practical matter, however, there are so many potential targets. It's unknown how the state is going to prioritize enforcement. Who do they want to make an example of, for instance? And they will want to make an example of certain companies, undoubtedly. And again, sadly, for those on the webinar today, drayage has been in the crosshairs of those attacking the IC model for some time. So it could be the case that many of you on the call could be on the radar already in California. There's no way to know for sure, but there's no way to sugarcoat it. Every day you are not in compliance in one way or another is another day of potential liability that you're facing. I will also note, though, that there were 12 legislators from the state assembly in California wrote a letter to the governor asking him to use his executive powers to delay enforcement or to exempt the trucking industry in some fashion. Some trade associations and others have echoed that request as recently as this week. I certainly applaud those efforts. I mean, I think we should be pulling out all stops. No reason not to pursue any possible theoretical avenue that's available. But it's not apparent to me what the governor can do or pursuant to what authority he could act. And at least what I've seen, I haven't seen anyone really articulate the authority. So that's a little bit telling in that regard. But again, no reason not to pursue it. And it may be that some emerging theories are available, but I wouldn't, again, sugarcoat it and suggest to any of you, don't worry, this letter was issued and there's going to be a transition period. We can hope for a soft enforcement period for the reasons I mentioned, perhaps, but you need to get in compliance. And then I think you asked about retroactivity, right, David?
Yes.
So here's the issue with retroactivity. It's unsettled right now, but I would assert that since the state was enjoined from pursuing enforcement for the last 2 years, that motor carriers that are operating during that period should be insulated from exposure during the term of the injunction, even though it was ultimately reversed. And I note that in the legislation itself, in AB5, there is some language that might help support that notion. It essentially says that in the statute itself, hey, if a court of law rules that this three-part ABC test set forth in the statute cannot be applied to a particular context based on certain circumstances, then you've got to flip over to the Borello test, essentially, is what the statute says. So in here, we've got a situation where a, quote, a court of law, the district court, did rule that the ABC test could not be applied to the trucking industry due to preemption, even though the Court of Appeals ultimately reversed it and stated its own decision. So I think there's an argument there. And I just don't think, and maybe I'm being too optimistic here, but I don't think that California will aggressively assert, probably I'm being naive here, that it can now retroactively take enforcement action related to that time period when the preliminary injunction was in place. It defeats the whole purpose of obtaining a preliminary injunction in the first place. It is intended to give you legal protection for not complying with a statute while the injunction is in place. So, I can't think off the top of my head of a situation where I've seen a state seeking retroactive enforcement of a statute for the period that a preliminary injunction was in place, while it was being stayed from enforcing it, essentially. So if the California decides to do so, the industry should, of course, be prepared to fight that. And it's possible, again, that this might come up in CTA's pending litigation. And given that it would be in front of the same district court judge at the time, the same judge who issued the preliminary injunction, I would think that he would quickly dispose of any such attempt to say that his preliminary injunction order really didn't have any effect. That's my take on it. Again, it's an unsettled area, but it's worth keeping in mind, I think. Does that make sense, David?
It does. It does. Thank you. As we all know, what happens in California moves across the country. So what is in store? Where do you see other states that might be following suit?
Yeah, New Jersey, of course, is on everyone's radar. It's already on the aggressive side, or the aggressive end of the spectrum, let's say, when it comes to worker classification. The New Jersey Senate had introduced a bill largely mirroring AB5. It was, I think, Senate Bill 4204 back in late 2019, but then failed to get sufficient traction. And certainly once AB5 was enjoined, I surmise that the state probably didn't want to get embroiled in litigation of its own until the matters were resolved in California. It may technically still be in committee, actually. Governor Murphy, has repeatedly and loudly voiced concerns over worker classification. He's a proponent of legislation like AB5. And some of my clients that are operating in or headquartered in New Jersey have shared with me they think there's a decent chance that New Jersey will ultimately take some next steps with respect to this legislation. Whether it can get through, who knows? Timing is really anyone's guess. New Jersey did just finish up its budget season very recently in the last couple of weeks, but in theory, they could turn to labor laws in short order. Illinois, you can expect, will be another jurisdiction that will take a hard look at this. Fundamentally, any state that has that type of political leaning is likely to be active in this area. So I encourage listeners, participants here to get involved in associations like IANA, similarly aligned operations, whether it's ATA or state associations. There's coalitions that are forming. There's one currently called Truckers Are Integral to the Economy that is currently trying to fight these battles in a very strategic way. So, please do what you can to try to head off these efforts in other jurisdictions to the extent possible.
Thanks, Mark. We've talked very much about motor carrier specific, but how will other intermodal stakeholders, steamship lines, railroads, 3PLs be impacted by this law?
Yeah, well, when you think about it, motor carriers, of course, their use of independent contractors as drivers has been truly foundational to the stability and the long-term success of the intermodal industry. And for decades, that's the model that they have relied on in supporting these movements, intermodal movements, whether they're by water or by rail, and they use independent contractors. So it's really been indispensable to the industry as a whole, largely due to the kind of operational financial flexibility that it offers to intermodal motor carriers, so they can adapt and respond to the volatility that we always see in the intermodal transportation market. So the kicker here, what to keep in mind for those in other modes is, whenever one participant in the intermodal market, whether it's a motor carrier, a railroad, a steamship line, is subject to operational inefficiencies, the other participants in that chain likewise suffer. It's a ripple effect. There'll be a decrease in capacity. That means in the motor carrier capacity, which means longer dwelling containers, for instance, poor utilization of equipment, even return of empties. Service levels will tend to suffer. There will be a general overall frustration on the part of all stakeholders involved in the intermodal industry. And that means shippers as well are going to be affected too, which they need to keep in mind. So you think about the magnitude of intermodal transportation, with the vast majority of manufactured goods in the world at one point moving in an intermodal container. And then you look at our market, the North American intermodal market, which has, $50+ billion in value. It's the largest intermodal market in the world. And you have hundreds of thousands of chassis. You're moving, over 50 million domestic and international containers a year. There is going to be a ripple effect that will affect rail and ocean just as much as it does trucking. So it's the interconnected nature of intermodal transportation.
Thanks, Mark. What did a little bit into the weeds? What is the effect of AB5 on a motor carrier's insurance coverages?
There are a couple of different things to keep in mind. Let's think about a motor carrier who converts to an employee model, for instance. If they do so, they're going to have to beef up their EPLI insurance, employment practices liability insurance. They're going to have more employees, so there's more risk of claims for employment discrimination, for instance. The same holds true with respect to other coverages, whether it's healthcare costs that you think about, increased workers' comp premiums because of the greater numbers, et cetera. And then if you think about the independent contractor drivers, let's say some of them who decide that they're going to convert to become small motor carriers, they're going to find that probably their biggest financial impediment is, David, is going to be their ability to obtain proper auto liability insurance. I have heard that the cost, we know that the cost of formation and obtaining authority, it's a cost, but it's not the dominant cost. The big cost is going to be getting insurance that will protect that given motor carrier. And I've heard ranges of figures as to what that could be. Some authorities say it's 20 grand probably all in order to convert from an independent contractor to a motor carrier, for instance, if that individual driver wants to do so. And that's could be pretty darn steep for a lot of operators, independent contractors out in the marketplace. So, but the bottom line, David, is that there are going to be a variety of insurance related costs that are going to go up. This isn't bringing anybody's insurance down.
Certainly not. And again, kind of a very specific yet relevant question, what do I need to do if I'm a UIIA motor carrier and use owner operators and also have company drivers?
Well, if you've got company drivers already, there's nothing new that you'll have to do there. They were employees, they'll remain employees. Your use of the owner operators is going to have to change, as we've talked about. Which of the various models we've reviewed is right for you will depend on the facts and circumstances of your particular situation in your business. It's not a one size fits all approach here. And I think that you might find in kind of a split operation like that, you may find that persuading the owner operators to join the rest of your team as employees, as company drivers, might be particularly challenging, because if you're already running both, there's a real reason why some are not employees. Why aren't they already asking for that? So, I think that from my perspective, again, this is more anecdotal than quantitative, but most, I think, are tending to explore that broker carrier model is the most viable, easy to implement alternative, but that's not necessarily the right approach for everybody. And even it carries an element of risk and no promise that AB5 won't necessarily be enforced against it.
What do I tell my owner operators about future employment?
Yeah, well, again, it depends on whether you do in fact intend to employ them or not. So the messaging with drivers needs to be handled delicately. It may turn on the nature of your existing relationship in large part. How strong is that relationship? You've been discussing AB5 in the past. I have a number of clients in California, and one told me after the ruling came down that the company was quite confident they would be able to pivot to an employee model due in large part to the relationship that it had with those individual drivers. And the difference there too is that this example that I'm using, they had a reasonably high margin freight in question that permitted the client to do what it wanted to do from an economic standpoint. That's not always going to be the case in drayage, unfortunately. But ultimately, you're going to have to notify drivers you've been working with about the model that you are adopting and that you will be not tendering loads to them under any other mechanism unless they work with you to deploy that new model, whatever it may be.
We're coming up on a few minutes left, but
Yep.
Let me get this last question if I can. What do I need to do if I lease equipment from a company or a driver leases equipment from the company but operates independently?
Yeah, leasing of equipment is not in and of itself prohibited by AB5. Again, depending on the model that a motor carrier adopts, it could find itself buying that equipment from a driver. It could end up paying self-employment income to a driver for leasing his or her truck to the company, as I was talking about with the two-check model, for instance. A motor carrier might end up becoming an equipment leasing company where it is leasing equipment to the motor carriers, the former individual drivers that are hauling freight that your broker entity ultimately tenders to them. So kind of consistent with some of the earlier responses, the starting place is always selecting your model at the end of the day.
And one final question is, and I'm going to lump two together. What are the chances that either the California governor or the administration will get involved in this issue? And you've kind of answered this second question already, but is there any further legal recourse to halt the enforcement?
Yeah, with respect to that first thing, again, I'm not holding my breath that anything formal, categorical is going to be done. I hope that the political forces at work, supply chain congestion, demonstrations, inflation, everything else has the practical effect of a soft enforcement for a period of time. But this decision did arrive at a particularly difficult time. In terms of legal recourse, there really isn't, let me put it this way. You can defend cases on the merits. You can still raise certain legal defenses, preemption under other theories, the Dormant Commerce Clause, for instance. You could try to argue that F4A still applies under a certain set of facts developed in your particular case. You can argue, like Uber and others have said, that, well, we think the AB5 is fundamentally irrational due to a host of exemptions that are already in the law. But at this point, the recourse is probably legislative at most, and it's entirely contingent on California politics. So when you take into account the art of the possible, it doesn't strike me that the California Assembly is going to do the industry any favors. Maybe I'll be pleasantly surprised. Even if a popular ballot initiative like Prop 22, but for the trucking industry, was advanced, I don't know if that's really a viable route. I mean, it was a real battle on Prop 22. I think it was the most expensive ballot measure in the history of California. $225 million spent on it, and now it's tied up in litigation anyways. So that's my take there in the final moment.
Well, that's fantastic. Marc, thank you so very much for all the information that you've shared. We really appreciate it. And also, we will be having a session at Intermodal Expo in Long Beach, California, September 12th to 14th. So if you want to learn more, then certainly register if you haven't. And we look forward to seeing you there. Marc, thank you again, and thanks to everyone for attending. Have a great afternoon.
Pleasure. Thanks, David. Have a good afternoon, everyone.